Well, welcome back, everyone, um, to our. Normally, we would call this the luncheon keynote. And perhaps it is. Perhaps many of you sitting around enjoying lunch while we feed your mind and your heart as well. I have the great privilege and honor of introducing our keynote speaker for today, and it is, of course, Judge Richard Lynn. Judge Lynn is briefly, and we have everyone's bios available, but just briefly, Judge Lynn is a circuit judge on the United States Court of Appeals, the Federal Circuit. He was confirmed by the Senate on November 19th, 1999, and I make that point because he assumed his duties on January 2000, and was sworn in at the stroke of midnight. So Judge Lynn is the first federal judge of the 21st century. One other quick note, because I could go on for hours about Judge Lynn, but you came here to hear him and not me. But I did want to note that one of the things that Judge Lynn is particularly interested and involved in is that he is an ardent supporter of the American Inns of Court. And the mission of the Inns of Court is to promote civility, ethics, professionalism, and excellence in the practice of law. And Judge Lynn is a past president of the Giles S. Rich Inn of Court for the Federal Circuit, which was the first American Inn of Court dedicated to pursuing these principles in the field of intellectual property law. And several years ago, Judge Lynn was so interested in furthering the Inn of Courts movement into the field of IP practice that he co-founded something called the Lynn Inn Alliance to get that number up from one intellectual property Inn of Court to 10 by 10, and he, of course, has surpassed that. At this point, it's more than double that number of Inns of Court. And the last note that I'll say about that before I turn it over is that it's particularly appropriate that we are partnering with the John Marshall Law School, which, of course, is located in Chicago, because the Chicago Inn of Court is actually named the Richard Lynn Inn of Court. And the members of the IP bar and IP community established that inn back in 2007. And so we're in the right place at the right time, and certainly with the most right of speakers. With that, I'd like to turn this over to Judge Lynn.
Well, thank you, Lateef, and let me say that it's a privilege and an honor for me to be here to join you at this incredible conference. And kudos to you and Professor Lim for organizing and arranging it and inviting all of the wonderful speakers and panelists. So it's a pleasure for me to be here. And as you say, I have a long-standing relationship with the John Marshall Law School because John Marshall has been part of the Lynn Inn since its inception. And you know that I have a deep and long-standing relationship with Howard University and the Intellectual Property Seminar, which you regularly host. Under your direction, Lateef, Howard has established the Institute of Intellectual Property and Social Justice, which has become really a virtual Washington institution. And the name of this institute, the Institute of Intellectual Property and Social Justice, has always been intriguing. And the acronym, IPSJ, is, shall we say, somewhat challenging. And I can recall a chance meeting with former Dean Schmoke at Penn Station in New York. We eventually got to talking about the Institute, and we both wondered aloud about the name and how it might be nice to come up with something simpler and more easily remembered. And in no time, the solution became apparent to us: Howard Intellectual Property, or as it would surely come to be known, HIP. And I'm told the acronym has caught on and is in regular use at the law school. I'm happy about that. But I've come to realize that the original name, despite the challenge of its acronym, has some real significance. At the 5th annual IPSJ seminar, I made the following remarks, which I believe are worth repeating. And here is what I said. This seminar is hosted by Howard University's Institute of Intellectual Property and Social Justice. Howard University was the cradle of the civil rights movement in this country and has been at the center of progressive thinking about the cause of social justice from its very inception. So what does this have to do with intellectual property, and why is it meaningful that this IP seminar is being held at this special place? The answer is that much of Howard's history is about courageous people who put their lives on the line to open the door to opportunity, not just for some people, but for all. Intellectual property is all about opportunity and the protection of individual rights. Opportunity based not on your ethnicity or your sexual preference or the color of your skin, your religious beliefs, or your station in life, but instead on your creativity, your ingenuity, your intellect, and your abilities. Intellectual property is about opportunity and protecting the creative rights of all people, whoever they might be. In that sense, intellectual property has much in common with the struggle for social justice. Now, social justice, of course, is all about the struggle to overcome adversity and compete on an even playing field to achieve happiness and success. Innovation is much the same. Inventors recognize problems and look for ways to overcome those problems and find innovative solutions. The coronavirus pandemic has presented us with a host of problems none of us anticipated 6 months ago. Suddenly, we went from a vibrant economy based on social and business interaction at all levels of society to a new world of limited and in some cases no personal interaction. But out of that adversity quickly came much innovation. Virtual interaction platforms developed overnight to provide new ways to interact. Businesses reacted to create new ways to deliver products and services. Health systems were developed to deal with a virus while continuing to provide regular care to those in need. And now schools are looking for innovative ways to provide education and social enrichment services. Within the legal profession, corporations, law firms, and courts have had to rise to the challenge and put technology to good use in delivering legal services and administering justice. For those of us in IP, this is really nothing new. This has always been our world. We are accustomed to dealing with and overcoming problems, but we regularly look for ways to find solutions and better ways of putting tools available to new and creative ends. In dealing with this crisis, we are already finding that what we've thought to be best in the past is not necessarily the most efficient or effective way. Within the legal profession, face-to-face interaction with colleagues and clients in an office was considered normal, if not essential. Hearings on contested matters in litigation were expected to be conducted in court or in a courtroom setting. And that meant renting appropriate office and conference space, commuting every day to and from work, and traveling frequently to meet with clients and appear for hearings. Many are now finding what I have known for years, that much of that is not necessary. When I became a senior judge, I moved to Florida, where I do all of my work other than attendance at oral argument in Washington. And now even that is done remotely by phone. I maintain chambers at the court. I have a career law clerk who works out of an office at the federal courthouse in Newark, New Jersey. I'm in regular contact with my staff by phone, by video conference, and by email. We have no trouble exchanging documents, editing drafts, conducting legal research, and debating issues, all without the time and expense of commuting or traveling. A recognition is emerging that spending time to commute to and from an office every day may not be necessary and may not be the most efficient or cost-effective way to get things done. And in the presence of the coronavirus, of course, it may not be safe. In view of the health risk posed by the pandemic, the Federal Circuit promptly took action after argument week in March and issued a standing order canceling all in-person arguments at the courthouse. Instead, the court has been conducting arguments by phone. The clerk's office, in concert with our IT group, has done an excellent job making the necessary arrangements. For each panel of arguments, the clerk's office calls each attorney and each judge and conducts a roll call to verify that the connections are in place and the participants can hear each other. The judge's law clerk's also on the call, but they can listen only. A separate phone line is also in place with a published number so that members of the public have the option to call in and listen in real time, much the same as if they were sitting in court. At the conclusion of the argument, the call is disconnected and the clerk's office then places a separate call to each of the judges on a secure line for the usual straw vote conference. Now, while phone arguments do not have the spontaneity or interaction of in-person argument, they can be effective and are a worthwhile substitute. I sat for phone arguments in May and July. I thought they went well and were helpful to the resolution of the cases that were argued. Now, some folks have asked whether the Federal Circuit has any plans to switch over to video arguments. The answer is presently no. I will be sitting by designation with the Ninth Circuit in November. That court has long streamed video arguments from court and is doing so now remotely. So I will soon have a basis for comparison. The Federal Circuit has a long tradition of entertaining oral argument in every case in which parties are represented by counsel. Because the phone argument procedure is logistically challenging, the court at first became more discerning, shall we say, about which cases to hear, which cases to decide on the briefs. But now that all of us at the court are more familiar with the process, we're essentially back to the usual practice of entertaining argument in nearly every represented case. Next month, we will entertain our first en banc argument by phone. That case, National Organization of Veterans Advocates versus the Secretary of Veterans Affairs, will address two important jurisdictional questions affecting veterans' appeals. Now, I want to shift gears a bit and talk a little bit about another challenging and changing development of late. Discussions about systemic racism, bigotry, and discrimination are all around us. Old ways are being questioned and re-examined. Leaders and important organizations are seeking solutions and new directions. The demographics of this country 50 years ago were demonstrably different than they are today. I can remember when I was in engineering school, there were very few women. Same for my law school class. Corporate offices and law firms were dominated by white men 50 years ago. But the complexion of corporate offices and legal departments is changing. And while the complexion of law firms is similarly changing to follow suit, we have a long way to go. But for some in IP, there have been notable changes in the right direction. When the Federal Circuit was formed in 1982, the court had one female judge, Helen Nees. 2 years later, the court had two with the addition of Judge Newman. But then the court went for 17 years before another female judge was appointed. I'm happy to say that we now have five. Judge Newman, Chief Judge Prost, Judge Moore, Judge O'Malley, and Judge Saul. Nearly half. And over that period, the number of women arguing before the court has increased dramatically. Indeed, it is not unusual for me to be sitting on a panel with two of my female colleagues, hearing argument presented by women on both sides, with me as the only man in the room. We now have one judge of Hispanic heritage, Judge Reyna, one Asian American judge, Judge Chen, and one openly gay judge, Judge Hughes. But notably, we have never had an African American judge. 8 judges on the federal circuit, myself included, have each had one African-American law clerk. My law clerk was the only African-American law clerk applicant I have ever had. And I cannot recall a single Black attorney ever arguing before me in the more than 20 years I have been on the bench. What is at the root of this inequality? Have Blacks been discouraged at seeking careers in science and engineering? Have they been discouraged at seeking careers in law? Why? Have they perceived a lack of opportunity? Do they not have the resources to afford an education? Are there disproportionate burdens placed on Blacks to earn money before even contemplating college just to make ends meet? Have companies and firms been reluctant to hire minorities? Now, I don't have the answers, but I know this is not right. Now, why is diversity important? Why not just leave well enough alone? Well, I think the answer, at least in part, lies with the fact that the disappearing old guard of leaders and decision makers don't have all the ideas needed to find solutions to the hard problems we now face and will surely face in the future. Different people have different ideas to share. Everyone brings something to the table. Let me share with you an anecdote to make the point. Several years ago, the wife of a good friend of mine who lives in New York decided to become a real estate agent. She is from Taiwan, and she speaks English moderately well, but she has a very strong accent. Shortly after the start of her real estate classes, a few of her well-intentioned classmates pulled her aside, told her the real estate business in New York was a tough business, and said that her strong accent would hold her back and she would never be successful. She was hurt, but not discouraged, and she pushed ahead. Ultimately, she finished the course, signed up with a large real estate firm in Manhattan, and became a top producer, selling high-end properties to wealthy Chinese American buyers. What her classmates failed to realize is that her ethnicity was an asset she could use to her advantage, not an obstacle to her success. As I said, everyone brings something to the table. Diverse points of view expand thinking and broaden the range of ideas under consideration. Businesses are increasingly diverse, managers and decision makers are increasingly diverse, consumers are increasingly diverse. It makes sense for service providers and those who sit in judgment both on juries and on the bench to reflect that new reality. The questions we must each ask ourselves is, am I a part of the problem or do I want to be part of the solution? And if the answer is the latter, one must next ask, how am I going to make a difference? Now, the IP-focused American Inns of Court have seen the challenge of the pandemic as an opportunity to lead the way in improving diversity within the intellectual property bar, and I'm very pleased about this. The Lynn Inn, for example, took advantage of a budget surplus resulting from the cancellation of its usual annual dinner to establish a $10,000 scholarship to be awarded to a deserving student at an accredited HBCU law school. The scholarship is named after retired Judge Orlando Keyes. Judge Keyes is African American, served with distinction for over 2 decades as a United States Magistrate Judge for the Northern District of Illinois. And I'm so pleased that he has given the Inn the honor of using his name for this new scholarship. The Nancy Atlas Inn in Houston is doing much the same, consistent with its longstanding commitment to improving diversity. Atlas Inn member Bill LaFuse serves as a trustee of the Foundation for Diversity in Intellectual Property Law, formerly known as the American Intellectual Property Law Education Foundation. The foundation has just embarked on a new and different effort at trying to encourage underrepresented groups who are STEM students to attend law school and become members of the patent profession. In the past, it has provided scholarships to more than 125 law students in the amount of over $2.5 million. The foundation is seeking increased participation by outstanding IP lawyers, and if you're interested, you can check out the website at www.diversityiniplaw.org. Now, I want to take a few minutes to talk about the importance of oral advocacy. And because we're all home watching streaming movies, I have a great movie to recommend to you. And that movie is My Cousin Vinny. In that movie, you see several examples of effective cross-examination of eyewitnesses, in each case casting doubt on their credibility in an entertaining way. Vinny Gambino followed the classic rules of effective cross-examination. Ask simple, short questions, use plain language, don't ask any question to which you do not know the answer. And you may remember the classic scene in the movie where Vinny very effectively presented the testimony of his expert in general automotive knowledge, Mona Lisa Vito. It's worth watching. Now, effective oral advocacy is critically important. Law schools don't really teach this. It's something you have to master on your own after you finish law school. And Chief Justice Warren Burger understood the importance of oral advocacy and the need for some sort of continuing education in this area after law school. He greatly admired the skills of the British barristers working out of the British Inns of Court. And in the 1970s, he perceived the need to improve advocacy skills of American lawyers and came up with a simple idea. The concept was to form small groups with members at all levels of trial practice, judges, lawyers, students, who would regularly come together, socialize, and learn by example and experience from one another. This led to the formation of the American Inns of Court, an organization which, as Professor Makima mentioned, I have been associated with for 20 years, and I'm a very strong supporter and great believer of what they are doing to promote ethics, civility, professionalism, and legal excellence. Interesting but little known fact is that Howard Markey, the first chief judge of the Federal Circuit, became the second president of the board of the American Inns of Court in 1986. He held that position until 1995. Under his leadership, the number of inns grew from a dozen to over 250. The number has now grown to nearly 400 separate inns across the country, and one, believe it or not, comprised of young American lawyers in Tokyo. I want to just close with a few observations about the complexity and frequency of changes in intellectual property over the last 10 years. In the 5-year period from 2010 to 2015, 7 judges retired or took senior status, opening up places for 7 new judges on the Federal Circuit. And while this was going on, Congress got into the act and in 2011 passed the AIA, which was the most comprehensive piece of patent legislation since the 1952 Patent Act. And pursuant to the AIA, the PTO established the PTAB and aggressively hired hundreds of new administrative patent judges. In the last decade, we went from a time when the Federal Circuit was essentially the only real decision-making body in town to a time when there were 7 new judges on the Federal Circuit, hundreds of new APJs at the PTAB, and now 4 newly appointed or relatively newly appointed justices at the Supreme Court, all engaged in the substantive decision-making of patent cases. And there was no shortage of patent cases and no lack of tricky substantive and procedural issues to be decided. All of this fed by a generally robust economy, an energetic and intellectually creative bar, and a host of media outlets looking for something interesting to report. And the statistics bear this out. The Federal Circuit decided 22 cases en banc in the past decade, as compared to 11 in the decade before. The Supreme Court decided 11 patent cases in the 2000s and 30 in the last decade. Now, I'm not saying that all of this change is bad. The sharp rise in the cost of district court litigation and the leverage that cost brought to the so-called patent trolls cried out for an alternative forum, such as the one provided by the AIA. And some early Federal Circuit rulings considered meritorious at the time were no longer sound and cried out for reform. The changes that have already taken place over the past decade or so have been dramatic and far-reaching. So what began 35 years ago as a steady and somewhat orderly development of a coherent body of uniformly applicable precedent has now become the subject of increased Supreme Court scrutiny, chased by increased Federal Circuit scrutiny, and now multiplied by significant PTAB activity. Change upon more change, energized by a heightened sophistication of the patent bar. These are all significant changes that challenge even the most diligent among us to keep straight. So the bottom line and the message I want to leave you with is that the waves of change are likely to persist for some time. But through all of this change, we must not lose sight of the importance of the patent system and the critical role it plays in stimulating innovation. Those of you who are in the trenches litigating cases and advising clients know best what changes are needed and what needs to be preserved and protected. Those of us in decision-making positions rely on you to help us make the right decisions and to strengthen and improve the system as we go forward. Thank you very much for listening. And again, it's my distinct pleasure to be here with you.
Well, thank you very much, Judge Lynn. Those were very informative and inspiring words. We have several people sharing notes of thanks, and I think one we may have time just to one question, and I'll try to sort of like make it a consensus question. And I think what a number of the comments have noted from your remarks is that the courts, the Federal Circuit, have seemed to move very quickly to adapt to change, particularly during this difficult period of not only the pandemic, but the broad national conversation that we're having on various social issues. Now, I having known you so well for so many years, I know if I ask you what advice would you give to other people, you would probably be a bit reluctant to tell other people what they ought to do. So I'll phrase it differently. It seems from your approach and the approach of your colleagues that you started out not only with an interest in needing the change and adapting to the change, but then also asking what questions do you need to pursue? What questions do you need to get answers to in order to meet the change and to implement what could be a good response? So I'll ask it that way. For other public institutions and private institutions, what questions do you think they might ask of themselves or ask generally that could help lead them to some of the information and the answers and ideas that will help them to implement the kind of objectives that they would like to see come to fruition?
Well, great question. And of course, let me answer it with a focus on the real problem that I see, and not only at the Federal Circuit, but at courts across the country. And that is the absence of Black advocates and Black law clerk applicants. Why? And I've been wrestling with this, and every time I came to hire a law clerk, I would look and see, well, is this another possible candidate? Is this somebody that I could relate to that might fill a void? And there was a dearth of candidates. Now, why is that? And I think part of the reason is that just, culturally, the African American community probably wasn't thinking about engineering as a career opportunity. I think the consensus view 50 years ago, I can't speak for the African American community, but I'm guessing that their thinking is that, well, I don't know, there aren't many Black engineers. I don't know that this is going to be a career. And same thing for law school. So I think there are two problems at this point, money and messaging. I think that there is a need for deserving candidates who may be financially stressed to have the funds in terms of scholarships and other support to go to engineering school and to continue on and go to law school and become patent attorneys and to become judges. So money is an issue. And everybody can do something about that right away. And that's what the Linen is doing, the Atlas and several other organizations. And messaging. And I do think the message needs to go out to the African American community in particular, that times are changing, corporations are changing, law firms are changing, courts are changing, the way people seek and administer justice is changing. There are opportunities, and there are great opportunities for engineers and for lawyers, and this is a field you should think about. And I do think between the money and the message, over time, I think that will make a difference. I hope so. And I'm open for any other ideas because, as I said, with that little anecdote about my friend's wife in New York, everybody brings something to the table. I don't care who you are. And it enriches all of us to have all of the different diverse views from people with cultures and backgrounds that differ from ours sitting at the table. So that's where I am.
Well, thank you so much, Judge Lynn. And in fact, I really appreciate your emphasis on the messaging, because if, to be completely honest, I think the messaging is a problem within certain communities and certainly within the African American community. And to some extent, it's because there tends to be this focus on, well, we've got, quote, more immediate problems. But one of the things that I like to emphasize in those conversations is that there are immediate problems and then there are long-term solutions. And we have to start thinking about the long-term solutions as well as the immediate problems. So your comment about the messaging was 100% spot on. So thank you, Judge Lynn. Thank you for your comments and for participating in today's conference. We do appreciate it.